Let me now tell you about a story coming in from Australia that has been making headlines. It's about Uber, the ride-sharing giant. If you use cab apps, you would be aware of the concept of cancellation fees. You know, when you book a cab and then have to cancel the ride for some reason and then have to pay a fee for the cancellation. Now, an Australian court has fined Uber $14 million. Why? For threatening cancellation fees it never charged and overstating fare estimates on some rides, basically breaking the consumer law. How exactly? The federal court ruled that the Australian arm of the US ride-sharing app misled customers with warnings that they would be charged for cancelling some rides from 2017 to 2021 and by using an inaccurate software algorithm to estimate the fares for a taxi service that it offered until August 2020. First, let me tell you what a cancellation charge is all about. After an Uber driver accepts a trip, Uber has a 5-minute window. During these 5 minutes, the passenger can cancel the trip without incurring any extra charges. But between December 2017 and September 2021, Uber misled users through its cancellation message. The message read, "You may be charged a small fee since your driver is already on their way." This was then changed to say, "You will not be charged a cancellation fee." Let me now tell you what the judge said in the case. In a written ruling, Judge Michael Hugo Bryan said that by supplying inaccurate information on its smartphone app, Uber would be expected to lead a proportion of consumers to alter their decision and not proceed with the cancellation and perhaps deter future cancellations while distorting demand for its service. The judge said the Uber taxi algorithm overshot the fare estimate 89% of the time, but less than 1% of the total Uber rides used that service. 89% of the time. Meanwhile, Uber, in a post on its website, had said that it apologized to Australians for the mistakes made and it has since proactively made changes to the platform based on the concerns that were raised. Uber will have to implement a compliance program and it will have to not communicate anything misleading about cancellation fees for 3 years. Now, this case is about more than just a fine. It is about misleading consumers. The Australian Competition and Consumer Commission, or ACC chair, Gina Cascodleb, said that the fine clearly signals to businesses that misleading consumers about the cost of a product or service is a serious matter which can attract substantial penalties. And this has been a pretty bad week for Uber. It has already agreed to a $10 million settlement with the city of Chicago. What is that about? For listing local restaurants in the Uber Eats and Postmates food delivery apps without the consent of the restaurants, and also for charging excess commission fees. $5 million will go towards paying damages back to Chicago restaurants that were affected. And this brings me to the bigger issue about the trust that one places in the applications that we rely on today, and what happens when that trust is violated. Cases like these bring to light how holding companies accountable becomes necessary. It is said that the best fine is the one not imposed, basically a situation where a company does not have to be asked to follow fair practices. Trust is a precious commodity, more so for a business that relies on that trust to keep its customers going the extra mile. To keep that trust is more important today than ever. WION now available in your country. Download the app now. Get all the news on the move.